Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're going to talk about fun legal terms, Latin terms, legal terms, things you can whip out at parties, or possibly if you ever find yourself in court, you can throw them around and sound just like an attorney. I get asked actually quite a bit from time to time about various things I've said on the show, and I try to define stuff when I use an unusual term, although the other day I said hoo-ha in reference to a body part. Did not define that. I figured most people would get that from context. Did not say hey nan or nanner, but that's another story altogether. But once in a while, somebody will say, what does this mean? What does that mean? And some of the stuff, like for instance, the concept of habeas corpus. Habeas corpus, people have heard of it. I might do an entire video on habeas corpus. But it's an interesting concept because the term is Latin and it actually means something kind of unusual, but it has a very specific legal meaning. So habeas corpus literally from the Latin means something to the effect of that you have the body or you have the body. And it's referring to a human body. And in the old days, we're talking a long, long time ago, back on the other side of the pond, in the common law, if somebody were to be seized or arrested by a local government official, a person could ask the monarch for a writ of habeas corpus, where they basically say, we want you to bring the person who's been held in front of you to determine if their detention is lawful. And what happens in America when you hear the term habeas corpus is that someone has been arrested or convicted in a state court, and the person thinks their conviction was wrong to the point where it's a violation of their constitutional rights, but they've exhausted their appeals in the state court system, and so they file a writ of habeas corpus with the federal court system. And they're, in essence, making the argument that I am being wrongfully detained here, and I want someone to review my detention to determine if, in fact, it's lawful. So habeas corpus, that you have the body or present the body, is actually referring to a human body. We've heard of habeas corpus. It's actually something that's preserved in the Constitution. It's something anybody can ask a court for. And you'll hear occasionally that it was suspended. And there have been times in our history, in fact, during the Civil War, where the writ of habeas corpus was suspended as a concept, where they basically said, look, we have a problem right now. We need to arrest people. We don't have time to straighten it all out. And so we're going to just operate without it. Obviously, doing that is a constitutional problem. But then again, the Civil War was a bigger problem as well. So we won't get into that. I'm now going to throw some other legal terms at you. And I will just try to, as best I can, explain these in plain English. I mentioned a while back a JNOV, and I said it means judgment notwithstanding the verdict, and I said that's got a Latin term to it. But JNOV stands for judgment non obstante verdicto, and it means judgment notwithstanding the verdict. And so if you're involved in a case, it's usually a lawsuit, and a jury comes back and awards something. If the award is contrary to the law, and it's obvious that the jury did something wrong, you can ask the courts to, in essence, overrule the jury. I know people don't like this concept, and it's a very, very unusual concept, but if it's obvious that the jury could not have returned that verdict and done their job properly, you can ask the court for a JNOV, judgment non obstante verdicto, or judgment notwithstanding the verdict. And courts can grant that. But as you can imagine, then you've got a great argument on appeal. Say, look, the jury gave me this money. Judge took it away. A couple of terms you often hear me throw around jokingly is et al. And et sec. Et al. Is et, next word al, and et sec is et, next set of letters seq. Et al. Means and others. And I often will tell you that a lawsuit was filed by Bob Johnson et al. Versus so-and-so. And et al. Means and others, meaning that the person I just mentioned to you was one of many people who are all in the same position legally. And so you'll often see a group of plaintiffs or a group of defendants, and it'll list one of them and it'll say et al., just to remind you that they're not alone in this. And et sec means and so on, basically. So I often refer to the law books behind me, and I say the Lemon Law is MCL 257-1401, and the Motor Vehicle Service Repair Act is MCL 257-1301, and I'll often say 1301 et sec, because the 1301 is the first section of a longer code. There's a 1301, 02, 03, 04, all the way down to the 40s or 50s. And so the first one actually just says, this law shall be known as the Motor Vehicle Service and Repair Act. So if you simply went and looked at that, you go, wait, that just tells me the name of an act. Well, yeah, it's that one and all the ones that follow it. So you'd say 1301 at SEQ, SEQ. I used the phrase the other day, ex party. It's two words, ex party. It sounds like a fun time, but it basically means that you're doing something without another party. And so I'm guessing that ex is Latin, meaning something to do with, no or without. And party, of course, is a reference to the fact that, we're using the Latin phrase for the same word in English, which is a party, in the sense of somebody associated with a lawsuit. So I'm the plaintiff in a case, there's a defendant I'm suing. If I run into court without the defendant there and ask the court to do something ex parte, it means I'm doing it without the other party there. It's very unusual that you do that, but it's often the case that you do that when you need to get a restraining order and you haven't got time to notify the other side. I've done it in a case where I hadn't served the other side yet. And I simply went into court and said, we're suing these people and we need an immediate order, blocking them from doing something. So that when I serve the complaint, it's going to come with, here's the lawsuit, here's the order. And then it'll also come with a motion for a hearing for the parties to all come in as soon as possible to rule on whether that motion I got, or the restraining order I got, whether that's going to stand or not. So that's an ex parte motion. It's done without the other party there. In camera. In camera is an unusual phrase. You don't hear this that often, but once in a while, somebody will stand up in court and say, Your Honor, I would like to introduce this into evidence. And the other side jumps up and objects vociferously. There's your word for the day. And the judge goes, well, what is it? And somebody goes, maybe we approach the bench. And you approach the bench and you're whispering with the judge. And one side says, hey, look, this is an extremely relevant piece of evidence. The other side goes, Your Honor, this is a major problem. And there's something wrong with it that we don't even want to discuss it in open court. And so in camera means that the judge will look at it, but outside of the presence of anybody else. So it's not going to be done in the open. It's going to be done in camera. I'm not sure why that word is used or what that word comes from in the Latin. Someone can look it up, I'm sure. But basically, the judge is going to take the evidence back in the courtroom and look at it and make a decision that he will then explain to the parties and, if necessary, to the jury. But it's not uncommon. That's done with extremely sensitive stuff. And I've also seen it done where there's a party, like where there's like a little kid, for instance, that the court thinks they need to actually speak to this little kid before determining whether or not they're going to testify or something like that. So an in-camera hearing or in camera is something that happens usually in the chambers of the judge, but not in public. And then the judge will then come out and make a ruling, usually on the record, and say, I've examined this document, and here's what we're going to do based on my examination of it. So it doesn't happen all the time, but it happens. In pro per or pro se, if you watch a lot of the sovereign citizen videos, you'll see this all the time when people appear in court without attorneys. And in pro per means in propria persona, which means in the person of yourself. Sounds redundant. And pro se literally means for one's self. But if you are going to go into court without an attorney and you are not an attorney, you are simply just a person, but you're representing yourself, you can say, Your Honor, I'm here in pro per. It's 3 words, in pro per. You can also say, I'm here pro se. And I'm not sure if there's actually a big distinction between the two. I think it's something you can use interchangeably. But in essence, you're saying, I'm here representing myself, or I'm here, on my own behalf. There's a couple of funny terms that I find fascinating from a legal perspective, but you don't hear them that often in the news. But it's a concept of additor and remediator. And I've mentioned before that a judge can overrule a jury's verdict, but the judge can also modify a jury's verdict. So let's suppose that I have a contract case against you, and I'm suing you for $10,000. And everyone agrees if the contract is breached, you owe me 10 grand. The only reason we actually go to court is to determine if there's a breach of the contract. So we go to court, and the jury comes back and we go, we give Mr. Lehto $5 million. Well, I'm not entitled to $5 million, as much as I'd like to take them. I'd be entitled to $10,000 if there's a breach. If there's no breach, I'm entitled to 0. And there are occasionally cases that are that clear-cut. But it's not always that clear-cut that requires this. But a judge could say, well, the jury clearly found there was a breach. They simply miscalculated the damages, which I will now, by remediator, bring down to $10,000. So a judge could hear a jury render a verdict of $5 million and say, on the concept of remediator, I'm going to knock it down to $10,000. Additor, as you might guess, is the opposite of that. So let's suppose the jury came back and said, we find a breach, we find in favor of Mr. Lehto, we give him $5,000. And I'd say, Your Honor, if there's a breach, I get 10. Everyone agrees to that. And the judge could say, based on the concept of additor, I'm going to bump it up to $10,000. So that's an adjustment that the judge makes to a jury verdict after the jury's rendered its verdict. Again, doesn't happen all that often, but it happens from time to time. And that's an emotion you'll often hear being brought at the end of a trial anyways, one way or the other, by somebody who's not happy with the, the jury verdict. Ab initio. Ab initio means from the beginning. And it's a reference to the idea that some legal things actually start at the beginning. So, for instance, if you marry somebody and later on something happens down the road and the question becomes, at what time did your wife gain rights as a spouse of a person? Well, that'd be ab initio. That was literally the moment they said, I do, and the judge or whoever it is says, I now pronounce you man and wife, or husband and wife. The moment they say that, boom, those rights begin, okay? And so you don't have to actually say, okay, you guys have been married how long? Doesn't matter. You had those rights since the beginning, ab initio. And you'll often hear that in contract terms or where they're trying to talk about when someone acquired rights or lost rights. And it usually is, there's a moment in time which is obvious where something began. And when that thing began, the rights that flowed from it also began. So ab initio, from the beginning. Genesis 1:1. Mens rea. If you watched Legally Blonde, you know this one. But mens rea refers to a guilty mind or the mental state necessary to be found guilty of a crime. And we all know that if you kill somebody, it might be murder or it might be an accident. Someone's going to die today in America by accident. They're going to get hit by a car. Someone's going to fall and hit them. That's an accident. Someone today is going to get murdered in America. And both of those are where someone gets killed. Someone dies. And so a lot of people, their knee-jerk reaction is, oh, this guy got killed. He must have been murdered. Well, no. If he got run over by a car and it's dark out and he's wearing dark clothing, it could be an accident. And so the way we would determine whether or not the person who killed somebody else is guilty of murder, for instance, is the mens rea. Did they have the mental state? Were they killing this person unlawfully for some unjust reason, such as I just walked up and killed a guy in cold blood, or a guy attacks me and I shoot him into self-defense? The difference there is my mental state. Why did I shoot the guy? Did I shoot the guy in cold blood because I heard he might be hanging with my lady? Or did I shoot the guy because he busted down the front door of my house and was on crystal meth and came in screaming and yelling and I thought he was going to hurt me, and so I shot him? Okay, the difference between those two things, besides the facts, is the mens rea, the mental state that I had when I pulled the trigger and shot the guy. Two of my favorite Latin terms, these aren't legal necessary, but legally by necessity, but you'll hear them from time to time in courtrooms. Ad infinitum and ad nauseum. And ad infinitum means taking something to the point of infinity. Like it just goes on and on and on. We could argue about this ad infinitum, meaning that we could argue about this forever. And usually it means we're not getting the ball moved down the field. Why not just stop now? But a slight twist on that is ad nauseum, which means that you're arguing about something to the point where you're just sick of it. And we've been arguing about this ad nauseum. Can we just make a decision now? Okay? So ad infinitum, to infinity and beyond, and ad nauseum, to the point where we're sick of discussing it. And we've all reached that point in one argument at one time or another in our lives. Amicus curiae or amicus brief. You'll hear the word amicus, and amicus means a friend, and so amicus curiae means a friend of the court, and they often file amicus briefs. And so whenever there's a case before the Supreme Court where one party's got an appeal against another party, but the underlying issue affects a lot of people, people will come forward, organizations and other people who say, look, even though we're not a party to this case, the outcome of it's going to affect us. Therefore, we would like the right to file a brief with this court, an amicus brief, where we're basically saying we're not a party, but we're a friend of the court and we're concerned and we have an interest in this. we're not trying to get involved simply because we're nosy Nellies. We want to get involved because we want to make sure the court understands how important this is, not just to these parties, but to the organization I represent or whatever. So an amicus brief or an amicus curiae, and we're talking about a friend of the court filing a brief with the court because they have an interest in it. Bona fide. Bona fide. You've all heard bona fide. Bona fide, as you know, you've heard the term and you can use it in a sentence. But bona fide literally means in Latin, good faith. So if you've heard the phrase semper fidelis, which means always faithful or ever faithful, it's the motto of the Marines, you'd recognize that fide is the root there, which means faith, and bona, like bone in French, which means, bon, which means good, bona fide, bona fide, literally means good faith. Good faith. And that comes up a lot in contract actions, especially the Uniform Commercial Code, where the parties are expected to treat each other in good faith. And they'll often refer to a bona fide error. When someone makes a mistake and it's a good faith mistake, it's not the same as making a careless mistake or making a mistake on purpose, if you can do that. And then finally, I'll end it with this because this is the least important thing here, de minimis. De minimis, which means about small things. And there's a couple Latin phrases that use that in longer form, but basically says that the courts or the judges or the people in power don't care about the smallest of things. So if somebody says, they're going to raise a point and the point is irrelevant because it's so minor, it could be de minimis, and so, or the difference between these two things is so minor we can't even see the difference, it's de minimis. So de minimis is one you'll hear quite a bit. It's got a nice ring to it, nice rhythm to it, and I use it from time to time. So those are the fancy pants legal terms that you can whip out at parties to amaze your friends. If I missed any, fire them below. Otherwise, questions or comments, talk to you later. Bye-bye.